Yet again, this labors under the assumption there is a thing like access, right of access to the Supreme Court. Okay, if you think so. But, yet again, this is a deep vision conflict, which either, and into which direction I want my Supreme Court to move. Whether it's supposed to be extensive review of individual decisions, which in the end, actually, if you allow for a historical sort of excursus, this model was not born because everybody would be interested in the individual. This model goes back 200 years to post-revolutionary France, as well as to absolutist monarchies on the continent. And it was about the state control, not about individual rights. Go away, individual, I'm not interested in you. It was either, when you look at the birth of, before there was Cour de Cassation, which is now the Supreme Court in France for criminal, civil, and commercial cases, there was a thing called Tribunal de Cassation, which was established immediately after the French Revolution, and it was considered to be part of the legislature. And was there, set in there, to extensively control the decisions of courts in order to prevent judicial encroachments and judicial transgressions on the sovereignty of the law. That's why there were given such a wide review powers, because the legislator and the new political power wanted to control the judges, who under the Ancien regime were considered to be the evil. They wanted to control them and have review of every single individual case so that the law is obeyed. Individual really didn't come into the game at all. And the same was really the centralization of judicial review in absolutist monarchies, including the Austrian Empire, at late 18th, early 19th century. Yet again, really nobody cared about the individual. It was reinvented later on with constitutional courts, constitutional review, and so on, but really it wasn't about the individual. Now I know you are looking at me, oh, this monster over there. No, really, I'm rather concerned about the function of the system. And from my experience, if the first instance court and even the appellate court was not able to provide justice in the individual case, it will never be remedied at the level of Supreme Court or the Constitutional Court. Sorry, but then we are just fooling ourselves, I'm bound to say. And this brings me to the last point, really, Constitutional Courts. Or how do they fit into the overall picture? Because so far, we had this vision of a nice three-layer or two-layer something system of the classical pyramid of judicial structure, which has evolved on the continent over the last 300 years. And what about constitutional courts? Especially in the context, as we have now seen, that it's most often the constitutional courts, apart from the political powers, but actually in judicial terms, constitutional courts, who are against the introduction of leaves to appeal, writ of certiorari, or selection, however you might call it, of cases or docket in Supreme Court. Now, in a way, this is logical. Why? Well, because in spite of the name, what constitutional courts have mutated into over the last 20 years, as happened before in Germany with respect, no, not yet, with respect to the Bundesverfassungsgericht, they are essentially the Supreme Court these days. Of course, I mean, in every decision of every constitutional court, I have the compulsory paragraph. The constitutional court is not yet under the regular court. It is there to safeguard the constitutionality, blah, 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 blah. I bet you've got it in Slovenian decisions as well. If you how the system functions 20 years after transition is essentially, if I have three conditions fulfilled, constitutional court is nothing else than normal Supreme Court. What do I mean by three conditions? Firstly, there is individual constitutional complaint, tailored really on the mother example of the German Federal Constitutional Court, Bundesverfassungsgericht, meaning Constitutional Court is a court entitled to review any single decision of public power, meaning administration, courts, and also the legislature. But important here are the courts. Why? Well, because from the executive, with very few exceptions, you never go straight to the Constitutional Court. You have to pass through the judiciary. And the specific abstract review of constitutionality, which is exercised vis-à-vis the legislature, is a bit apart. But in this system, how the German Federal Constitutional Court, the Czech, the Slovak, now the Hungarian, and a number of other throughout the region work. If you've got individual constitutional complaint, in about 90 to 95% of cases, the Constitutional Court does nothing else than review final decision of other courts. Either the Supreme Court or lower courts in cases when there is no cassation or complaint, revision, whatever you like, to the Supreme Court. So in a way, it functions as nothing else as the regular Supreme Court in terms of instance. Secondly, as far as I'm aware, none of the constitutional courts in the region was ever able to define what is a constitutional question. Right? Because as the dogmatics work, constitutional courts are there to protect the constitutionality, which is supposed to be something else than legality. Right? Courts, ordinary courts, are there to uphold legality, meaning law has been observed, procedure correct, and so forth and so on. On the other hand, constitutional review, individual review in constitutional cases, defines itself as protecting constitutionality, basic rights, and so forth. And the underlying assumption there is constitutionality is qualitatively something different from mere legality. In other words, not every breach of simple law, everybody has borrowed this from the Germans, einfaches Recht, something like that. So it's mere law as opposed to constitutionality. And a mere breach of simple law is not unconstitutional or may not be unconstitutional. The problem is, this works very nice in textbooks. However, I've never seen a test which would be able to determine what is a mere illegality and what is unconstitutionality. So, we have a system in which I have individual access from all the echelons of judicial hierarchy to the Constitutional Court, combined with inability to define the jurisdiction. I'm not able to tell you what's constitutional question. If the Slovenian court has the key, I'm very happy to hear it, but I haven't seen it. Which then means it's completely arbitrary. To give you a beautiful illustration, which I always like because it was one of the decisions, my decision, back at the Supreme Administrative Court, was an Ukrainian couple called Mrs. and Mr. Petrova, who applied for asylum in the Czech Republic somewhere 2003 or something. The problem there was that, the procedure was conducted in Czech. They had a right to interpreter if they ever asked for. They never asked for an interpreter. So the entire procedure ran in Czech. The review before administrative courts ran in Czech. They communicated with the authorities, everything was fine. But then they popped in a constitutional complaint against the decision or the final decision of the Supreme Administrative Court, plus the decision of the Regional Administrative Court in the first instance, saying that their constitutional right to fair trial has been violated because they didn't understand the language. Right? So there was a procedure led against them in which they were not cognizant of the language. Now the funny bit was that both of them, Mr. Petrov and Mrs. Petrov, both filed complaints to the Constitutional Court, which landed in different senates of the Constitutional Court. One senate said, well, this is manifestly inadmissible. Absolutely no constitutional right has been touched, even by far. The other senate said, oh yes, blatant violation of constitutionality, I annul it and send it back. But these were completely identical cases, right? Because both of them have been dealt together throughout the administration, both of them filed identical administrative complaints to administrative courts, so everything was identical. You cannot get any better case of seeing that the division between legality and constitutionality is just really, I know it when I see it test, but it doesn't exist objectively. So that was the second thing. And the thirdly, what one had observed over the years in Central and Eastern Europe, as before in Germany or Spain or other of the earlier generation of constitutional courts, is the change of discourse. Meaning, the Constitutional Court, or constitutional courts here, start imposing themselves through the language of constitutionality on ordinary courts. Meaning, things like which they have inevitably copied from Germany is the Ausstrahlungswirkung, Drittwirkung, and so forth, meaning the radiation effect or the effect of constitutional interpretation and horizontal relationship, imposing this discourse on ordinary courts, who then are obliged, in order for their decision to withstand the review in the Constitutional Court, to change their rhetorics. You are obliged, if you are under a court these days, and you want your decision to be constitutional proof, you are supposed to pop in your considerations of fundamental rights, of constitutional conform interpretation, haven't taken into account that cautel and that maxim, whatever you like. But this changes the rhetorics of the system, because the constitutional courts impose themselves and change the discourse gradually so that it penetrates all the decision making of all courts. And by this, they essentially alter the system, and they really do become Supreme Courts for all areas of law. You are not able to distinguish what and why, and all of it will be eventually reviewed by the Constitutional Court. Coming back to the final point, what of Constitutional Courts? Well, if we want to introduce some selection of cases and some speed up of judicial delays, well, unfortunately, the place to start is on the top, not on the middle level. So from this point of view, it's very difficult to introduce selection and speed up the things at the level of Supreme Court or appellate courts if above that is a constitutional court which acts as a revision instance for everything. And from this point of view, constitutional courts will always be opposed to selection, logically, to selection of docket on the level of the Supreme Court. Because you can hardly allow your appellate court to have a power which you don't have, and which will in the end distort your own docket. Why? Well, because, finally I can draw. Because what will inevitably happen if you have this are appellate court, these are first instance courts, and this would be the Supreme Court. Once you start limiting access here, so the things will end finally here or even here, the next question, the next thing will be, oh, cool, constitutional complaint, right? And by this, if the system or if the constitutional court were to allow for selection at the level of Supreme Courts, then unless it follows lead or it starts, all the cases would land in the constitutional court, and they would just circumvent the problem of docket and delays, and the next congestion or the next problem would be the constitutional court itself. Right, I have been talking for too long, really. Conclusion. Sorry, I have none.
Don't worry, you're still participating in the roundtable discussion, right?
Oh, no, thank you.
So we'll be also able to pose questions at you at that moment, and you'll be able to make your conclusions then.
Yeah, perhaps by then I can think of some. But, no, as I said at the beginning, really, it's very broad. And it's very difficult to offer, oh, this is the solution, and this is the way forward, and this is what you do, and this is when you implement, this will be miraculously solved. No, it's a complex game of complex factors, which obviously must be played with goodwill from both parties. So no just sort of extra and putting the problem on someone else, and oh, it's their problem, no, not ours. Yet again, it must function as a system. If it doesn't function as a system in a symbiosis, it will never function. And in the end of the day, really, I mean, you will be talking a lot in the next few days, I understand from the program, about the things like Udla and Lucenda, and the cure and non-cure, and the satisfaction there and satisfaction here. But please, let us not forget, Lucenda itself is the anomaly. Solving these cases, which have been coming to the European Court of Human Rights from all Central and Eastern European states, so please do not feel in any way sort of, oh, it's only us, we are beaten up. No, it's not you, it's everyone. Which also is kind of fun if after sort of 6 or 8 years of proceedings on one instance in Strasbourg, you get the message, oh, 4 years, two instances, too long. But yeah, sorry, it's an inter parenthese. No, but I mean, the roots of the problem itself are really down there, I mean, on the first level or a second level, and they are not limited to providing just satisfaction on the national level. This is really sidetracking from the core problem, which is for a state to be able to provide a decent, reasonable service called justice, not expose just satisfaction of a few thousand euros to someone who has had the nerve to do it for long enough. Right? So from this point of view, judicial delays are just the external appearance. And solving judicial delays is definitely not by throwing money by someone, but rather looking back at the roots. Thank you.
Okay, thank you very much, Michael. This was really good.
I don't know about a leader, but you are
It's
not
hard to
entitled
find
break or
somebody
something.
with such a great passion for lecturing and for the theme that you were debating.
I was just trying for them not to fall asleep, okay?
I'm sure they weren't. So now we have a 5-minute break, and we continue with our next lecture. After our next lecture, we have a bit longer break with refreshment and everything. So I will invite you downstairs, and you have like, vi imate 5 minut da se oživite i
To smo razmene.
Are you now indirectly saying to me that they didn't understand anything what I was saying?
Moja babica od njega sa
No, pa klikni. No, klikni pa samo potrdi. Ja.